He's a good boy. He's never bitten anyone. If I had a nickel for every time an insurance adjuster quoted that at me, I'd be retired on a beach in Florida. But here's the reality in Indiana. Just because a dog hasn't drawn blood before doesn't mean the owner gets a free pass to be reckless. Insurance companies want you to believe in the one bite rule. This idea that a dog gets one freebie before the owner is liable. That is a flat out myth. Today, I'm showing you how we win these cases by exposing the knowledge gap and proving that the owner knew their dog was a threat long before he bit you. When you're bitten by a neighbor's dog, you're at a disadvantage. It's called the knowledge gap. The owner knows everything about that dog. Every growl at the mailman, every time it lunged at a kid, you know nothing. You just know that you were walking by and got hurt. The owner is gonna play dumb. They're gonna say that the dog is a gentle giant. But Indiana law doesn't require a previous bite to prove that the owner was negligent. We just have to prove that they knew the dog had dangerous propensities. So, what counts as a dangerous propensity? It's a habit that makes the dog a threat to others. You don't need a medical record of a bite. You need evidence of behavior. In Indiana, we look at common law negligence. This means the owner has a duty to exercise reasonable care to keep others safe from their animal. If they know their dog is aggressive or even just highly territorial, reasonable care might mean a higher fence, a stronger leash, or keeping the dog inside when guests are over. If they fail to do that, they breach their duty to you. It doesn't matter if the dog's record was clean for 10 years. If they were careless today, they are responsible for your bills. Watch out for the trespasser defense. This is the insurance company's favorite trick. They'll claim you weren't supposed to be on the property to avoid the owner's responsibility. But here in Indiana, if you were a social guest, a neighbor, or even on a common walkway, you aren't a trespasser. They use this defense to make you feel like the accident was your fault. We don't let them get away with that. We look at the facts of where you were and why you were there to shut that defense down. So, how do we find the truth? We perform a neighborhood audit. We don't take the owner's word for it. We go door to door. We find the neighbor who doesn't let their kids play in the yard because of that dog. We find the Amazon driver who refuses to deliver to that house. We find the close calls that never made it into a police report. If you've been hurt, don't let the insurance company tell you you don't have a case. Call the Mark Lopez Law Firm and let us do that digging for you.